whom? Petition. Yes, what is this, madam? Government? Time can be granted. She wants time. Request of learned counsel for the petitioner relist week after next. Yes.
97.
90.
Serial number 89, Your Lordship. Serial number 89, Your Lordship.
Yes. What do you want,
And for
madam?
the petitioner, Your Lordship, 1 week's time may be granted, Your Lordship.
What happened to the
Estimating-
what happened to mediation?
It did not seem like it would settle, Your Lordship, although the party said that they could have tried, but it did not seem like any successful result would come.
You're for petitioner?
Yes, Your Lordship.
Request of petitioner relist next week.
Yes, Your Lordship.
97. Serial number 97.
90?
97.
Yes, what do you want?
Not a week's accommodation for the petitioner.
Nobody is appearing for this GM Institute of Technology.
No, my lord. The university, my lord, is the contesting party. My lord. It's a formal party.
Request of counsel for a petitioner relist after 2 weeks.
Obliged.
ಕೊಡಲ್ಲ ಅವ್ರು ಕೊಡಲ್ಲ ನಿಮಗೆ. You are for institution. You don't want to pay. Your seat has got vacant or you have filled up the seat. We will not consider. Go and get some judgments. At request of counsel for petitioner relist after 2 weeks. Yes. Yes, government. But we will argue after 2 weeks at request of counsel for the petitioner relist after 2 weeks. Interim order, if any, stands extended till next date of hearing. 90. Who are you? Petitioner. Rahul Karya. Already you wait when the matter is called, you can please. You finished the last page?
Number 20, 101 and 102.
Yes, madam. $45. Yaro. GMCPC. The unused postal cover steps alle ideyalla. At least you should take the 45. Request of counsel for petitioner relist next week. Yaro. Huh? He's not at all here, Boregoda. Boregoda's name is not here. Request of counsel for appellant relist next week. Did he die? Surrender, it abates already. It is already abated by law, sir. Request of counsel for petitioner relist after 2 weeks. It abates. What do you have to do? Do that.
My lord, serial number 4, my lords, I'm appearing for the petitioner. The prayer has become infructuous, my lords.
We'll call out. We'll call out.
Sorry, my lord. Sorry.
4 weeks time. 1 and 2, 4 weeks to comply. 1 and 2, 4 weeks. 3 weeks. Yes, 4.
My lords, the prayer was sought for permitting me to appear in the final year exam, my lords, which by order of this honorable court, I was permitted and I have completed my course also. So the prayer has become infructuous. I had sent my colleague, my lords, my sincere apologies. He has not yet reached the court. So I will file the necessary memo, my lords. The petition may be dismissed has becoming infructuous and the
Another
liberty
counsel
may
for
be
the
reserved, my
petitioner,
lords.
Sri Karthik B.Y. submits that by virtue of the interim order granted by this court, his prayer is met with and he has taken the examination. Thereby, the writ petition has become infructuous. Hence, he seeks withdrawal of this writ petition as having become infructuous. Hence, writ
My
petition
lords,
is
one more submission, my lords.
as having infructuous.
My lords, one small submission, my lords. Now the institution is not granting me or handing over me the original documents and the completion certificates and all, my lords. So I require to file a fresh, on fresh grounds, I have to file a writ petition so that liberty may be preserved, my lords.
You don't need liberty, sir. You go and file. If they don't give, you have the right. You
Much
don't need
obliged,
liberty.
my lords. Much obliged, my lords. Much obliged.
File a memo.
Certainly, my lords. I will do it in the day, in the course of the day, my lords. In the course of the day, I will do it, my lords.
Not signed in the ಮಾಡಿ ಇವಾಗಲೇ ಮಾಡಿ. And what are the objections? Not ಇವಾಗಲೇ, whatever is. The council is permitted to rectify the objections raised by the registry. We'll have it next week. Relist this matter next week. In urgency, idea. 2 weeks. 2 weeks. You file objections. Four weeks time granted. 6 and 7. The council submits, he will do the needful within a couple of days. Release this matter next week. There is no reference, no representation on behalf of the petitioner. By order dated 15/9/2022, this court has passed peremptory order of dismissal of the petition if the steps are not taken within a period of 2 weeks. Nothing material is placed before the court to show that steps are taken, and there is no representation even today. Hence, petition stands dismissed in view of the order dated 15/9/2022.
Number 10. Yes.
Where? Where? First title of? Ah. What is the name? Gagana. Male or female? Male or female? A.S. Gagana andre son of Chandrappa ಅಂತಿದ್ದೀಲ್ರಿ. ಫೀಮೇಲ್ ಅಂತೀರಾ ಡಾಟರ್ ಆಗ್ಬೇಕಲ್ವಾ? What is it? So what have you mentioned in your plaint? Who are you? You are appearing for this Gagana or Ganganna? What is mentioned in the plaint? In the judgment and in decree, it is correct. Yes, Ganganna, son of late Chandrappa. You have to at least show your plaint what you have said. If the court has committed an error, I will overrule it. In both judgment and decree, it is correct. What have you said in the CP? In CP, what have you said? You changed suddenly to Gagana, daughter of Lata Mani. Oh no. Learned counsel to rectify the objections raised by the registry. 2 weeks time granted. You should be convincing the court to accept your submission. The judgment and decree is correct. You come up.
I beg to appear for petition.
Huh? Who's appearing for the petitioner?
Yeah, I beg to appear for petitioner, my lord.
You have to
In
take
this
out.
case, no, my lord, notice is not required for them because the first respondent appeared through the council. At the instance of the first respondent, amount has been deposited before the court.
So what about 2 to 4?
2 to 4 need not require because, my lord, they have not filed any claim against us. And they have accepted the only one part of the amount which is deposited before this honorable court.
What are you challenging, Mr. Naik?
I have challenged, my lord, application filed by the first respondent stating that all the amounts shall be deposited. Whatever proceed arise out of the land acquisition proceeding by the BD, the entire amount shall be deposited. Then this honorable court be pleased to order one portion shall be deposited.
Who was filed IA 1 of 21 for
Yes,
withdrawal?
I have filed, my lord. I have filed because suit came to be dismissed by virtue of RA 113/2015 on 6/10/2020, my lord.
You
So
are plaintiff
therefore,
or defendant?
I am defendant in that suit.
Suit came to be dismissed.
Dismissed, my lord.
Yes.
So
Your
in
challenge?
RA
What is any stay is granted?
no, my lord.
Very fine. Conciliation. Good. All right, you explore whatever you are doing. I'll relist this matter at request of counsel for both parties next week.
Please.
No, whether the deletion of R1 is going to affect you. Who's R1? No, what is his rank in the trial court? Sir? Defendant number 1.
He has sold his property before filing.
To you.
I filed an application to come on the card as a party member. That has been allowed. That is the subject matter of this. This situation.
So R1 may not be required. R1 may not be required. He's a party to the proceedings there. Dispense, why you want to delete? You dispense notice. Learned counsel for the petitioner submits that respondent number one, who is the defendant number one in the trial court, was placed ex parte and has not contested the matter. This is you're challenging the application filed by him, which is allowed. Accordingly, notice to respondent number one is dispensed at the risk of petitioner. Your plaintiff. Let- Here or here?
Yes.
Ah.
The date of death is not mentioned and it is like, how is that you want the dispensation of notices, there are some respondent. Not to the respondent.
Then your application also will go. Called file a memo. Then in view of dispensation of notice to respondent number one, originally defendant number one, who was subsequently died, the applications filed by the petitioner IA number 1 to 3 to bring the LRs on record and to set aside the abatement are sought to be withdrawn as not pressed by the petitioner. Accordingly, applications are dismissed as withdrawn.
Is one to the quoting. I'm not sure.
Notice stage alla ideyalla, how it can be allowed. No, IA number 1 to 3 of 18. He wants to dismiss that and he wants
He wants to.
One verse to 3 of 2020. Because I got the LRs of respondent. That I got. Respect of IA 1 to 18. Like really allow that.
LRs of
System
the R1 and R2 antide. Wrongly typed.
IA 1 to 18, not 18, 3 of 18 is bringing LRs of petition.
Respect of IA number 1.
Second serial number in respect of R1.
So IA 1 of 18 to 3 of 18 is to bring LRs of a petitioner. So he's a plaintiff. How many plaintiffs are there? So that has to be allowed. Who are the LRs? Copies are served to you. That can be allowed. IA Code 1 to 3. Yes, you want to bring them on same persons. Where are they? Lakshmi Devi, Sharadamma, Gurumurthy, and Prahalada. Correct? Who's the fifth one? See, here you have 4 LRs. He says there are 5 LRs before the trial. IAS number, orders on IA number 1, 2, and 3 of 2018. These applications are filed by the petitioner to condone the delay of 858 days in filing the application to bring the legal representatives of petitioner on record, to permit the legal representatives of petitioner to come on record in the form of petitioner 1, Roman 1 to Roman 4. And to set aside the abatement as against the petitioner. Full stop. Objections to these applications are not filed. However, learned counsel appearing for the respondent submits, the respondent number 2 submits that he has no objection in bringing these petitioners who are LRs of the original petitioner on record, as they are already brought on record before the trial court. Full stop. Having perused the affidavit annexed to the application, I do not find any legal impediment to allow the application. Accordingly, these 3 applications are allowed. Delay of 858 days in filing the application to bring the LRs on record as condoned. The petitioner is permitted to bring on record the legal representatives of petitioner in the form of petitioners 1 to 4, Roman 1 to Roman 4 on record. The abatement is set aside against the petitioners. Then counsel for the petitioners to carry out the necessary amendment and file the amended petition by serving a copy of the petition, amended petition, to the counsel for the respondents. That's all. That is dismissed because he has withdrawn it. Huh? What is the suit for? Are you in possession?
Only on this ground.
No, your application is allowed. He's challenging that. We'll consider. I will have to consider that on merits. Kindly. Here you. No date. We'll list this matter a week after next. Come ready for arguments on this. Yes. Interim order, if any, stands extended till next date of hearing. When did he die? The council seeks time to take necessary steps. We'll list next week. Rashid Khan. There's no representation. Relist. You are respondent. What do you want? What's your submission? First day. Last. No representation on behalf of petitioner. Relist at next week. A week's time is granted. If needful, then issue notice to respondents number 2. I'm taking the report to serve. Oh, none appears. What is this withdrawal? Memo for withdrawal of
I'm from the petitioner.
Lakshmish.
My lord, I filed a memo for withdrawal of the petition.
Suit is disposed.
Yes, my lord. The matter is compromised between the parties.
The counsel for the petitioner has filed a memo dated 20th June 2022. Memo reads as under. Is submitted by learned counsel, who's present through video conferencing, that the suit has been amicably settled.
Yes, my lord. The execution proceedings. Final decree proceedings have been settled.
The final decree proceedings have been settled between the parties amicably, hence the petition has become infructuous. Hence, the petition is dismissed as having become infructuous.
Grateful.
The council submits that he would do the needful during course of the day. Interim order, if any, stands extended, relist next week. R4. When did the R4 die? R4, death yavaga? 4 months. At request of learned counsel for petitioner released next week. There a counsel Usharilla. Sachin. There's no representation released next week on either side. Narasimha Murthy. There's no representation on either side released next week. In office objection. Non-compliance of office objections raised on IA number 26 filed by Narayanappa. Who's Narayanappa? For LR, sir. You are Narayanappa. What is this application? Why can't you comply? What is the objection? ಇಲ್ರಿ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಒಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದಾರ ಅದು ಗೊತ್ತು ನೋಡಿಲ್ಲ ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಲಾಸ್ಟ್ ಮಂತ್ ವಾಟ್ ಆರ್ ದ ಒಬ್ಜೆಕ್ಷನ್ at request of counsel correspondent number 6B relist next week comply it, otherwise we go against you. You can't keep matters of 2015 pending because of your convenience. Either go on or take a order. Next. Chandrasekhar Reddy.
I pay for the petitioner, my lord. I request for a week's time to do the needful, my lord.
This IA is filed for bringing LRs on record.
Indeed, my lord. There are two IAs. One is to condone the delay to bring the LRs on record.
Why can't you serve the copy on the other side?
I have already sent it on
Each time is granted to comply.
Number 23.
No representation on either side, release week after next. A week's time is granted at request of counsel for petitioner. Withdraw the petition. What is the order that you are challenging? Rejection of written statement. So now the suit is dismissed. But Learned counsel for the learned counsel representing the petitioner files a memo seeking withdrawal of the writ petition on the grounds mentioned in the memo, which reads as under. Full stop. So this petition is dismissed as withdrawn, reserving liberty to the petitioner to revive the writ petition in case the trial court does not allow the writ petitioner to file the written statement. Accordingly, writ petition is dismissed as withdrawn.
I am for the petition, my lord. Weeks time may be granted to taking steps. 26.
How can your
But
which
26.
case? Which
I am
case?
for the petition.
Which case?
Serial number 26, man.
Varadaraj
ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ ನೀವು? Which is this case? Which is their WP number?
WP number 37212.
I think you are in the wrong court. Yes. You're the 26 ಅಲ್ಲಿ. Whose R1 and 2 was filed? Prithviraj. Anybody else has come on record? Prithviraj, BN Prithviraj. Nobody else has come on record. How can we be permitted to retire? Cannot be permitted to retire. Interim order, if any, stands extended till next date of hearing. Relist this matter next week. Buddy, you're ready with synopsis? All right. You want a week or 2 weeks? 2 weeks. You serve a copy on EGA also. Two weeks time granted. If needful done, issue notice to R4.
I am for the petition, my lord. Sorry, my lord. Weeks time may be granted to taking steps to against R9, man. 28.
Yavril 28 alla.
28 ali. Sangmesh
Are
G
you
Patil.
correctly submitting?
Yes, my lord.
37212.
Yes, my lord.
All right.
Yes.
2 weeks time granted. If needful done, issue notice to R9.
R9. Bacho.
Withdrawal. Rule 5. There is a 14 person. Call out the name. Divine Verma. Sudhir Tolpadi. The party in person, namely Diveen Verma, is called out. He is not present. However, a memo is filed seeking withdrawal of the writ petition. Memo reads as under. In view of the memo seeking for withdrawal of the writ petition, the writ petition is dismissed as having become infructuous according. Any other applications? No applications. When did R4 die? 2020. It stands abates. Now, when is the death reported? Yeah, are you sure about the death date? Petition as against R4 abates. Madam, when is the date of death? Anything reported in the sheet? Which order? As per the order date, so and so, it is seen that the respondent number 4 has died on 19/4/2020. Therefore, the petition as against R4 abates. Yes, what do you want next? 2 weeks time granted. File an application. Purna. 2 weeks time, if needful done, issue notice to R2 and 3. Same order. Notice to R3. No, copy is not given. Letter counsel for the petitioner to furnish one set of copies along with annexures to the learned AG. Yes, both 32, 33, same order. No, this petition is filed by whom? So what is the court fee you have to pay? There is a question of further court fee. There's already paid 100 court fee. Okay, court fee to be paid against the number of students. Where are the students? It's the institution which is before the court. Order. What are you seeking? What are you seeking now? What do you want? What are you seeking? Pay the demand notice. Who appeals for respondent?
He does not inform me that he will not.
He is not appearing. colleague, the objections raised by the registries with regard to payment of court fee as against the number of students. It appears, but from the writ petition, it is seen that the petition is filed by the institution. Question of payment of court fee of students would not arise, hence office objection raised by the office is overruled. Deal is next week after next.
Bill number 35.
2 weeks time granted if needful done, notice to R4. Issue notice to R4, madam, you have to write full sentence. Full sentence, very big. What is unclaimed? Unclaimed is what is to be done? Who's petitioner? Shrikant. Who are you? Notice to R8 is unclaimed. Then what is the complaint by this R8? None appears. None appears for the petitioner relist. Week after. Who are you? You are complainant and 8 also is complainant. Can you made a complaint to the government? You have not taken. You have not filed any. So the government has already taken action based on the complaint.
Based on whatever the directions we have taken action.
So your complaint is answered by the government. Now you have complaint stating that there is arrears. Government has issued notice to the institution to pay. That is challenge. Let him come. He has to. I can't hear you in his absence. Relist week after next. No representation on behalf of petitioner. Counsel for R7 and Leonard AGA is present. Huh? No, that you don't now interrupt the court. You have to say either at 1:30 or come on the next date of hearing. Interrupt. Huh? Process fee for? You're not given. What do you want to do? Petitioner seeks time, 2 weeks time granted. Needful done, issue notice to respondent.
I appear for the petitioner in this case, my lords. The
Hmm.
matter has become infructuous, your lordships. The main matter has itself been disposed of, your lordships. They're living together. The parties are living together.
Parties are living together. So you want to withdraw?
Yes, your lordships.
Learned counsel for the petitioner submits that the main matter has been amicably settled between the parties and they are living together.
Yes, your lordships.
They are living together. Hence, in view of the submissions placed by the learned counsel appearing representing the petitioner, this petition would not survive for consideration anymore. Accordingly, petition is dismissed, having become infructuous. Submission of learned counsel is placed on record.
Pleasure.
Madam, congratulations. You have now made two people join together.
Yes, sir.
Syllabus 39.
Likely to be settled. Settlement ಮಾಡ್ಕೊಂಡು withdraw ಮಾಡ್ರಿ. Likely ಅಲ್ಲಿ withdraw ಮಾಡ್ಬಿಟ್ರೆ ಅದು ಲೈಕ್ಲಿನೆಸ್ ಹೊರಟೋಗ್ಬಿಡುತ್ತೆ. You're for the wife. So he wants to join or he wants to separate? He wants to join. Separate. So you want to withdraw? What? That is inherently available to you. Learned counsel for the petitioner files a memo. Memo reads as under. Learned counsel submits that the parties are intending to amicably settle the dispute between themselves. Accordingly, he seeks to withdraw this petition. In view of his submissions on the memo, his petition is dismissed as withdrawn.
From 40.
On taking of steps in respect of necessary application, deceased respondent dated 15/9, 15/9 order noted. When is the deceased died? There's no representation on either side. Release this matter after 2 weeks. Jagadish, Registrar Judicial Report, Financial Condition of Petitioner, memo of retirement. You have filed NOC Vakalat. Filed. Then we'll delete name of Jagadish. Learned counsel Shri Mohan KN has filed a NOC Vakalat from the previous counsel. In view of the same, learned counsel Shri Jagadish D. Hiramat, who has filed a memo of retirement, is permitted to retire, and registry is directed to delete the name of learned counsel Jagadish D. Hiramat from the cost list. What is the next judicial report in the financial condition? What does it say? So, what is the report of the committee, the registrar? There is a report. This is the evidence. Examination chief by Shri Mohan KN. ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರ ಅಲ್ಲಿ? There is a report, judicial report regarding financial condition of petitioner 27/9. You have not seen the report. Report kept below ಅಂತ ಇದೆಯಲ್ಲಮ್ಮ. You are not aware. In perusal of the records, it is seen that the report of the registrar judicial is not found in the file. registry to trace out the same and place it before the court, released after 2 weeks. For what? Let it come. What is the hurry? Then what is the petition? No, what, for what?
Yes, find RFA before the start of court. And we need to find this 5 lakh passport fee. Can see no source of income.
Krishna Bhatt. Yaar, the claimant, huh? You're there in this case? Are you in this case? Claimant's appeal. Tatkali. IE number 1 of 14 is filed to control the delay of 116 days in filing the appeal. Full stop. Delay of 116. I have perused the affidavit annexed to the application. I do not find any legal impediment in allowing the application. Accordingly, delay of 116 days in filing the appeal is condoned. IE 1 of 14 is allowed. Next. Kumaraswamy. Same format you have to maintain. Delay of same format you have to maintain. Want me to dictate again? Delay of 44 days is condoned. IE 1 of 14 is allowed. Recalling 7-4. IE 1 of 16. Put it. Seven 4-16. Italy 1-4-16. Serial number 46. None appears released next week. You have filed for vacating. Right. Order sheet. What is the order? Interim order of stay granted. RDJ order. So annexure M is your. So what is your annexure M? Asking you to close the school. But you have not given them any opportunity of notice to answer, reply. Yes, have you filed objections? Hmm. Hmm.
1 week time may be granted.
What statement do you want to file for objection to vacating? You need not file, sir. This is writ petition. For what? You have already taken interim order of stay. Now you have to argue for vacating what she has filed vacating. The school is running. What school is it? Standard. From which class to which class? You have high tension wire running over your head. Who gave you permission?
The unattached portion of building which is being laid to items by that has been taken down. Submitted to some-
You placed any materials, madam, how the school is, photographs and other things? Why did you give permission? Yes. All. Yes. Yes, you answer. Learned AGA has filed an application. State has filed an application IA1 of 21 for vacating the interim order granted on 16/9/2021. Objections to the said applications are not filed. However, in gross violation of the notice and without caring for the welfare and safety of the human life of the children, the school is proceeding to conduct the activities of the children whose lives are put at stake. Hence, the petitioner to immediately answer to the application IA1 of 2021, release this matter next week. You can't play with the lives of children circumstances. You show whatever you have taken correction method, you have to show next week. Yes, party in person, James. Permission to submit written arguments filed by the petitioner party. ಹೊಸ VC ಬಂದಿದ್ದಾರೆ. Yes, Mr. James. You obtained Form A, B, and C, all that in order. No, I'm asking whether the Form C certificate, B certificate is obtained. Vidya, record alli, party in person. You went to the committee? Form B is given. What is this matter? What is a prayer in your writ petition? Which course?
Law course. 3 years LLB. I'm a retired student.
The law degree. Why you are stopping from? He's pursuing the education and securing.
Legally issue వస్తుంది. So, you want to rewrite.
All right, now you are going to argue the matter yourself or somebody else is going to come on? All right. Mr. A.J. James, party in person, is present before the court. So also learned counsel Ganpati Bhatt for R1 to R3. Learned counsel for the respondent submits that the entire files have been taken back by the Vice Chancellor. Vice Chancellor. New Vice Chancellor. Hence he is unable to go on with the matter without the files. Hence, I deem it appropriate to relist this matter. We'll have it next week after next. Yes, we'll give which date you want. Week after next. Choose the date week after next. 17th, 18th? Huh? 18th? All right. We will see on 18. If they appoint somebody else or he gets the file to argue, we will see on that. We'll try to decide. You can place it. You have filed or you have. Now, have you filed your written arguments? All right, it will be considered. For what? Where is the written submission? Aye.
You went to US for 3 weeks. Not yes, not completely.
Your copy kottidara? Have you received? All right. So you want to also address the court, or you will be restricting only to the written argument? No. You will not be given both options. Either you address the court arguments or you rely on written argument. You cannot have both options. Take the choice is yours. This, all right. Then you will not be permitted to argue. They will be permitted to argue. If they argue, you want to reply, you are entitled to reply. Yes, you can reply. Have you given a copy of that? All right. Relist this matter on 18th.
50, my lord. I appear for Karnataka State Law University, madam.
Yes, madam.
I have filed detailed objections, my lord.
Filed?
Yes, my lord. Matter may be taken up for final hearing.
My lords, counsel for the petitioner, my lords.
Counsel for the petitioner as well as counsel for the respondents are present. Full stop. Counsel for the petitioner seeks time. Relist this matter after 2 weeks.
Obliged, your lordship.
Obliged.
Third violation.
Huh? Yes.
Means the evaluation conducted by the third evaluator as per this ordinance. Yes, a deviation not supported by two evaluators. The general evaluation is equal to the decimal. The algebraic formula will be the total mark and then the maximum discrepancies. The answer paper goes to third evaluation. Here the paper mirrors is for second case. So the valuation, the difference is more than 15. Therefore, I'm seeking for a situation evaluation of the third evaluator for only one paper, that is section. Okay, urgency mirrors is section A, page 27. A notification is issued by the Rajendra University that the examination mirrors commenced.
Yes. Does not filed wakalat also. The counsel for the petitioner is present. The counsel for the respondents 1 and 2 is not present. We will have this next week. No, when is the examination? 23rd. When is the last date for filing?
The last date for payment of fee is 17th.
17th.
But they'll have to undertake this process.
Third. Release this matter on 6th. Released on 6th, you mentioned whatever stage it comes. Same stage. Release this matter on 6th. Inform the counsel to inform the counsel for respondents about the urgency of the matter. Just bring him Sachin next time. We'll pass some order. Annexure A. What is annexure A? Not if it was not recognized.
But however, the wrong.
11. That time it was recognized. It was recognized. So he is passed out in 2011. 2011 joined. So you cleared, passed out in 2013. And when was the non-recognition? So 13 to 15. Yes, what about the other, you are appearing for all the respondents? Notice has to go. So now you are seeking to declare that as null and void. We have to hear the other side. Third learned counsel for the petitioner issue notice to respondents number 2 and 3. Mele learned AG is present representing the state R1. Yes, madam, that's all. Who's the counsel? Is there a panel counsel for UGC? What about Open University? Sunge. Learned counsels. The registry to show the name of learned counsel Rajendra Kumar Sunge for respondent number 2 and the learned counsel Shauri HK, na? HR Shauri for respondent number 3. Learned counsel for the petitioner to serve copy of these petitions to the respective councils of R2 and 3. All right. We list week after next. Yes, Suresh. There's no representation. Finish. On either side. We list week after next. Nagaraj. Huh? You filed the suit for what? Declaration and injunction. That is in 52 of 2013. The defendant number 2 filed suit for partition. That is in 75 of 15. So the partition suit is decreed. And your suit? Dismissed. Who has filed RFA? You have filed RFA, which is pending here. On the allowing of the partition suit, the RA is filed before by the appellate court. So you want both to be transferred to This regular first appeal is pending before which court? RFA 1146 of 2018. It's pending before single bench or division bench? Single bench. Where is the other side? Where is your friend? Let your friend come. Relist this matter week after next. Huh? Interim order idea. Yeah, sir, where is your application for stay? Stay is granted. So what has stayed now? The proceedings in RA stayed. RA. Interim order granted earlier stands extended. Release this matter a week after next. Sense of directions to registrar judicial for inquiry of petitioner financial status in indigent. Inquiries come for inquiry. Illa. Who are the respondents? What is wrong? Issue notice to respondents. Harish Kumar.
56.
Issue notice to respondents. In the meanwhile, learned counsel for the petitioner is permitted to take out notice of this petition on the counsel representing the respondents before the appellate court, regular appellate court. Gopala Krishna. Huh? For what? For what? You are practicing for how long? ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ನಿಮ್ದು ಪ್ರಾಕ್ಟೀಸ್ ಆಗಿದೆಯಾ? 11 years. ನಿಮ್ ಸೀನಿಯರ್ ಬರಲ್ಲ, ಅವರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಇರ್ತಾರೆ. ಕೃಷ್ಣಸ್ವಾಮಿ ಏನಕ್ಕಿದೆ ಇದು? ವಾಟ್ ಫಾರ್ ಇಟ್ ಇಸ್ ಫೈಲ್? ಯು ಹ್ಯಾವ್ ದ ಫೈಲ್. ಫೈಲ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ? ವಾಟ್ ಇಸ್ ಚಾಲೆಂಜ್ ಸರ್? Liability. They have satisfied the amount or not? They're shifting the liability on the owner. Correct. They want to shift it on the owner. We'll stay it. And hear you. Heard. You're already served, Allah. Any other persons to be served? Services complete? You're for R1, Allah. Claimant. So R2 is the owner. Third learned counsel for the appellant. There shall be orders on IA. Order agil Allah, yeah, Ali. Whether any order is passed on the IA? Agir huh? Paper publication. Stay in IA number 1 of 14 agir stay agidya. Have you deposited 60%? ಮಾಡಿದಾರಾ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಲ್ರಿ you ask him, he doesn't know ABCD of his case. All right, there's no point in admitting this. What is the amount granted? ಆಗಿದೆಯಾ 4,424,000 ನೀವೇನು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ. Learned counsel for the appellant insurance company seeks time to release next week. Records to be secured from the jurisdictional tribunal. Forthwith. Yelin barbeku. Forthwith. Next.
Appear for the third respondent, my lords.
Yes, there is O Mahesh. What is this, Mr. Ravi Shankar?
My lord, this is now the appeal is by one of the insurance companies. The facts of the matter is the claimants are the legal representatives of the pillion rider. There is a collision between a van and a motorcycle. Tata AAG is the insurance company to whom I represent. They are the insurance company of the motorcycle. The van insurance company is the Sundaram, Royal Sundaram Alliance, who are the appellants before my lords.
Yes, that's the fourth respondent before the tribunal.
Yes, my lord.
What van is it? What van?
Some Maruti van.
Okay.
The tribunal comes to a conclusion that the negligence of both the rider and the driver is 50%, and awards compensation. In other words, the occurrence of the accident, quantum of compensation are not in dispute before my lords. The only point that the insurance company is now attacking is regarding the apportionment of negligence to an extent of 50% on the ground that the charge sheet is filed against the rider of the motorcycle, and therefore the tribunal fell in error in saddling the liability on both the insurance company is their principal ground. My lords, the tribunal has considered Exhibit R7, which is the spot sketch. Admittedly, both the insurance company officers are examined, but no eyewitness is examined in this case. So the
FIR is filed against the motorcycle?
FIR is filed against the driver of the van, but the charge sheet is filed against the driver of the motorcycle.
So charge sheet is against the rider of the motorcycle?
FIR is against the driver of the van.
That's okay. So the charge sheet filed against your client, that is
yes.
It is not challenged?
It is not. Nobody is. None of us have challenged. The fact of the matter is the tribunal comes to a conclusion that the spot sketch would indicate that the accident has taken place in the middle of the road, and both the vehicles have contributed to the accident. That is the finding of the learned judge.
Yes.
This is now before my lords in challenge.
So Mr. Mahesh has to convince me on why it is not correct. He's not here. So you want a passover or you want some other?
As my lord, Mundin vara haku.
All right. The learned counsel Mahesh is not present. Learned counsel Ravi Shankar for R3 is present through video conferencing. Deal is this matter. On 10th?
Great.
10th.
60, my lord, I am for the respondent.
Ah.
I seek for a week's time in this matter, my lord. Some file has been misplaced. Only for this reason, my lord, I am seeking time. I will.
Srinivas, you are for respondent.
My lord, I am in 60.
Ah.
I am for respondent.
Correct. He's seeking time because his file is misplaced.
Oh,
At request of counsel for the appellant released next week.
Much obliged.
Positively go on with the matter.
Yes, my lord, I will.
Don't seek time in these old matters.
No. My apologies. I will.
Next. Prakash. MU Punacha.
Ready for the second respondent.
Where is Prakash? Yes, sir. One person is there, the other one is not here. How to dispose of?
They ಬೇಕಾಗ್ತದೆ their presence.
No representation on behalf of appellant Leonard Counsel for R2 is present, released next week. Lakshmikant. Lakshmikant. No representation on either side, released next week. Jagadish. HT Jagadish. Order sheet ಕೊಡಿ. There's no representation on either side. They released this matter on 11th January. Shantaraj. There's no representation on either side, released on 12th Jan. Lingaraj. I'm interested. Here, at least final hearing, somebody should be here. Passover ಏನಾರಿದೆಯಾ? ನಮ್ದು ಯಾವ್ದು passover ಇದೆ? $68 ಅಲ್ಲ? ಕಲ್ಯಾಣ್ Pass over. Pass over. Sir, you are ready in the matter. Ready to argue? Why? Why pass? You are ready? Argue. For what? He's ready to argue, let him argue. Your claimant is seeking enhancement. Argue. Disability, yeah. It's a case of injury. Argue. Yes. Disability the entry. Yesterday. Doctor is treated doctor or non-treated. Yes. Date of accident. Are you reading the file now? Or are you ready with argument? For what possible? You have not read the file. Really? All right, pass over. Pramod, Ashok Kumar, pass over. So no need of citation. I will look at the citation you argue. Your claimant. What have you asked? It's a case of death or injury. 2013 accident. Yavaga accident. Sir, you forget about citation, you argue. You don't have file. Well, you come to High Court without the file. You have to come at 2:30. The case is dismissed. Where is the other side? The counsel for the appellant is present. There's no representation on behalf of respondents. The counsel for the appellant is not ready to go on with that matter. Release this matter on 6th. Get ready on 6th, otherwise I'm going to dismiss this As it is dismissed. 75 alva ivaldu. Same, that also is same. Whether that is dismissed or allowed. How many years you are practicing? 2 years. 2 years. That is pretty allowed. In 75 only, the counsel for the appellant is present. You are appearing in 75. 74 you are ready. He is not ready. 75 learned counsel for the appellant is not ready to go on with the matter as he has not read the file. Due list on 6th, both matters. This is your opponent. Case of death, what is the age? Date of accident? Age? Age? Have you produced any proof of income? What? He was working as sales coordinator. What was his salary? Have you produced? Examined? Whom have you examined? Whom have you examined? Who's he? ಅದರಲ್ಲಿ ಇನ್ಕಮ್ ಕೊಟ್ಟ ಮೇಲೆ ಯು ಹ್ಯಾವ್ ಟು ಎಕ್ಸಾಮಿನ್ ಎಂಪ್ಲಾಯರ್. ಫಾದರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಿ? ಎಂಪ್ಲಾಯರ್ ಹ್ಯಾವ್ ಯು ಎಕ್ಸಾಮಿನ್? ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಯು ಗಿವನ್? ಮಾರ್ಕ್? ಎಕ್ಸಿಬಿಟ್? But to be quick, sir, you can't keep coming and searching here. What is this? Sorry. There is no representation on behalf of respondent number 2. Learned counsel for the appellant is present, ready to go on with the matter. Relist this matter on 6th. Inform Mr. P.B. Raju to come and argue. Kelista? Inform him. If he comes, then I'll dispose of him. Withdrawal of the appeal. Where is it? The claimant's appeal. What is it? Claimant's appeal. Dispensation. Yes. There is a memo. You don't have a copy? Why you want to withdraw? Hmm. The Learned Counsel for the Apparent filed a memo dated 12/12/2022. Memo reads as under. The counsel for the appellant submits that he would want to withdraw the appeal as the respondent owner of the offending vehicle is not found unable to enjoy the fruits of the decree. Once placing his submission and memo on record, appeal is dismissed as withdrawn. Have you filed it? When did you file? 12/12. Yeah.
Matters number 79 and 80 adjourned.
Huh? You are the dependent. So they withdraw the suit, suit is dismissed. Hmm.
It's not what is passed. I don't know. The super itself was not in existence.
Suit is filed for what?
Possession.
Suit for possession. Now you are in possession.
And possession by the full break. That has calculated in the stating that I am so they do this.
So sale deed has come to concluded contract. So you have a sale deed, you are in possession. It's a residential or agricultural? Agricultural. Measuring? Now suit is restored.
Now, the delay is controlled and miscellaneous proceedings. That was state meeting.
So what are you challenging here?
I did not ask.
Condoning the delay.
Because not please. Inquiry must have been made. 3 years. So, until the date of this application, just was happening. Assuming the
As on date of?
the filing of the petition, seller's petition, they do dispute and the company also. There is no purpose of no useful purpose of this contract.
Application is filed under which provision?
Also not.
What is 9 rule 9?
If you against 20 by default, last question. There is suit is only a party decision rule 8. Plaintiff shall be precluded from bringing a press suit. In apply for an order suggested to dismiss, be satisfied, dismiss the court that there was sufficient. Here we not into the defendant, but to apply for the final memo resort for the dismissal without seeking any rebuttal. Please come to under 23 note or 23 rule.
So in this case, the plaintiff has appeared and he has filed a memo for withdrawal. Where is the question of this rule 9 coming into play?
Exactly.
Because rule 9 is subject to rule 8. If it is dismissed in rule 8, only then rule 9 will come into play. So rule 8 is where the plaintiff does not appear, whereas he has appeared. What is this posted now for? Final hearing है this? B group. Where is the other side? Where the suit is now proceeding. So now you're challenging the miscellaneous. Any order is granted? Where is the order?
Petitioners have no knowledge about this. They ask about the case, then they get you to do it. Used to make them cultural events. Later on, they get to know their. The second body disease. The sexual was not. We have 2 years, 4 months in filing. Case the inquiry must have been held in press all the year. Not they are recruited from the clear.
All right, let the other side come. Current counsel for the petitioner is present. There's no representation on behalf of respondent. Release this matter next week.
Arita? Declaration. Without making relation that is concerned. The application they will be. So you read me as a. Application. Is that the definition to be with process. Not this.
By you, filed by you. So in what?
This also.
So one allowed, one is rejected. Huh? So that is not challenged. But before this court, place that the same order will follow.
Yeah.
So that's saying that this will meet the same fate. This case will meet the same fate. A learned counsel for the petitioner, who was the applicant, in which OS matter, which is that? OS number 140, OS number 149 of 2010, filed an application to implead himself in the suit proceedings, which came to be rejected, agreed by which he is before this court. Full stop. He contends that in a similar other matter, he had filed an application for impleading, which came to be allowed or rejected? Which came to be allowed, which came to be rejected, and same was challenged before this court, and a coordinate bench of this court has allowed the same, permitting the applicant to come on record. So the said matter would have a bearing on this case, hence he wishes to place the same before this court. Let's release this matter next week. Guru Prasad.
Number 83.
There's no representation on either side. Release this matter next week.
84.
Ashmita Nayana. There's no representation on either side. Release this matter next week. For what? What do you want? Right? Huh? Senior counsel not available. What is this case?
I think that during the pendency of this housing audit, no notice upon him all the things before the order.
What's the difficulty for you to argue? Henry senior counsel is the matter only. None of you are interested in going on with the matter. We have reached almost 100 matters and 12:30. What short date, sir? It is day after tomorrow at request of counsel for respondent. Yes. E8, Shiv Prakash, SDN Prasad. Passover. Passover. Serial number 90. Passover. Mike ಇದೆಯಲ್ಲಮ್ಮ ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು ಮೈಕ್ ಇಸ್ ಪ್ರೊವೈಡ್ ಯಾಕೆ ಸೀನಿಯರ್ ಬರ್ಬೇಕಾ
Milord, in 92, I appear for R4 and 5.
Yes, Mr. Senior Counsel.
Yes, Milord, I am ready now.
Yes, argue, madam. What is the case? You have to argue. Who's going to argue? You are going to argue or senior is going to argue? When? 1 week. Mr. Senior Counsel.
Yes, Milord.
Is there any adverse order against you here?
There is no adverse order, Milord. This is the problem is this litigation has been going on for the last 30 years. That is the only.
The way the counsel for petitioner is going on, it may go on for another 10 years, I guess.
Yes.
What is the suit filed for?
There is a suit for partition. And they said, Milord, there was no partition in the plaint. Suit was decreed partly. And then, Milord, I am a purchaser for value. And, Milord, in the appeal, when after the arguments, then, Milord, they filed an application saying there was a partition. Then, Milord, entirely a new ground. No, that is, Milord, a ground which is inconsistent with the earlier ground was taken. And because earlier, there were earlier proceedings.
1987.
Yes, yes. This is, my lord, this is actually a luxury litigation, my lord, instituted. That is.
And madam, when your senior is going to argue? You fix a date, Mr. Senior Counsel. If he doesn't
Very well.
come, we'll. Learned Counsel, what's your name? Mangala. Srimati Mangala is present on behalf of petitioner. Learned Senior Counsel, she, Ms. Subbarao, who represents respondent number 4 and 5 of Manjula R. Angadi to video conferencing. You are appearing for 6 and 7, sir. 6 and 7. At request of learned counsel for the petitioner relist this matter on 13th. To tell your senior to argue on 13th. Interim order, if any, stands extended in the state. You are appearing for whom? Institution. Student. So his admission is not approved. Which course? Which course?
Yes.
Not approved. Which college? So college is not in filed a petition? All right. Good. Learned counsel for the petitioner seeks time. Learned counsel for you for respondent 4, 3. You are not filed wakalat. Filed. You are appearing for what is authority? For R3, Yogesh Naik is present. Relist this matter week after next.
Sorry, my lord, I'm sorry. Current, there was no disconnection, my lord. So I'm sorry I could not make that submission.
Doesn't matter. So this is adjourned to 13th, Mr. Senior Counsel.
Much obliged, my lord.
I was asking whether you are appearing for R6 and 7 or R4
Yes,
and 5.
R6 and 7, my lord.
Yes, noted. Noted.
Yes,
Respond number 1, my lord.
This is yesterday's matter, is it?
Other matter, different matter.
Similar matter. So you are an institution. Yes. All the parties are here. Why?
With respect to informal current. If they have
You are appearing for? The NCISM is national. This is a new one which is coming to place. What is your stand?
now the answering respondent will be the yes. There it was
Central government was to take the decision, but now. Gautam appears for
Respond number 1, my lord.
central government.
Yes, my lord. My lord, whether NCISM, that is the interpretation, my lord, who should.
Deputy ASG is here, no? Deputy. He's in one another matter, connected matter. So you're appearing for two matters, he appears for one. So your argument will be same. Yes, what you want to rely here? Let me understand, what are you relying here? So what was the deficiency? What were the deficiencies? Now, by this you are asked to reconsider. So have you reconsidered? All right. When is that matter listed? No. So you want similar arguments in this also? No, both are similarly placed. In this present. So in this present writ petition where he is appearing, in this also you reconsidered? No order was passed for reconsideration. So first round of litigation. So first round. All right, well, I'll hear him first. But learned counsel for the petitioner as well as counsel for the respondent. Respondents are present before the court and through video conference respectively. This matter deals with the educational institutions for having incurred certain orders for deficiencies pointed out by the respondent number 2. That is NSCIM. INCISM. Similar matters are posted on 23rd, hence these matters be listed on 23rd, along with the other matters. That is in what is the number? Is the number. So you go on with the matter on 23rd. You got a copy of this? That will be better. You have received copy of this? It need not be connected ಮಾಡಕ್ಕೆ ಹೋಗ್ಬೇಡಿ. It is later.
I appear for the petitioner, my lords. 96, my lords, I appear for the petitioner.
Also to be listed on 23rd. Mr. ASG, where is he? He appears in this CGSR. No, he doesn't appear. Dodward Saras Chandra appears. Madam, your Manasi is here. But this also on 23rd. Yes, Rajat.
Please, my lords. I appear for the petitioner, my lords. My lords, in this, we have challenged annexure A, my lords, at page number 16, where, my lords, the petitioner institution is a hotel management institution run by the petitioner number 1 trust, my lords. For the academic year 2021, my lords, the permission was not given and it has been placed for no admission for the year 2021, my lords. Page number 16, my lords, is an impugned order. In my lords, in the chat, serial number 1, my lords, an expired lease deed of 15 years is presented on documents not accepted in the deficiency till exist. On issuance of this annexure, my lords, we approach this honorable court, and this honorable court, my lords, given an interim order dated 12/10/2020. In pursuant to that,
Okay,
my
you
lords,
are
we have
appearing for
submitted the
This is responding to murder.
My lords, the answering respondent would be the respondent number 2, my lords, AICTI.
Who appears for R2? You are ready in the matter? This is that particular year. 2020 to 2021. So this year to 20 to 21, the permission was not granted. Complied. All right, yes, proceed.
My lords, now the subsequent development which has taken place, my lords, we have already submitted all the documents to AICTI for the subsequent 2 years, my lords. Pursuant to that, my lords, they have given a permission for the admission, my lords, of the 2 subsequent years. In pursuant to that, my lords, this court directed the respondent number 2 to ascertain whether it's a true fact. If so, my lords, if the permission has been given, the problem is resolved, my lords. Anyways, my lords, the order has to be passed to an extent, my lords, because if the no order has been passed in pursuant of an interim order, the students have been admitted. Hence, my lords, if they don't have an objections, my lords, the petition may have to be allowed to an extent, my lords, to regularize this students who have been taken a course through the interim order. If the AICT, my lords,
for which period?
My lords, for 2021, my lords. Now, my lords, for 21-22, they have given a permission. For 22-23 also, they have given a permission.
What has been granted? EOI, the extension of approval. That is granted for the year 21-22 and 22-23. No, this EOA is granted for 21, 22, 22, 23. For what intake? 40.
My lord, the intake, my lords, is increased from 40 to 60 for the year 22-23, my lords.
All right. So now what is this petition is filed for what?
My lords, Annexure A, my lords, page number 16. Quashing of the said.
Annexure A.
Please, my lords.
Okay, what has happened in Annexure A? Read Annexure A.
My lords, Annexure A, my lords, the chat which has been there. The first point, my lord, was a major issue. The deficiency was not uploaded properly, my lords. My lords, there was a technical glitch because in my lords 2020, all the documents were supposed to upload it online. For a moment, my lords, the institution is established in the year 1994. The approvals have been granted in 1997. From then, onwards, we have been in possession and we are running the institution, my lords, without any problem. Due to some technical glitch, my lords, we are not able to do it. And subsequent development also, my lords, giving approvals for the subsequent 2 years. There was a misunderstanding, my lords. The communication gap was there by uploading the documents properly, my lords. Only for that reason, my lords, the Annexure A was issued. Now, my lords, for the 2020, 2022 and 23, the intake has been increased from 40 to 60. Hence, my lords, the AACT does not have any problem, my lords. Hence, my lords, the only reason why I'm insisting for an order, my lords, because in pursuance of the interim order, the students have taken the course and completed, my lords.
How many students you have taken for the period 2021 are admitted? How many students are admitted?
My lords, as on filing of the petition, my lords, 34 students were admitted. Exact number, my lords, are.
For which course is this?
My lords, hotel management, my lords. Hotel management and catering technology course.
So your intake. So your intake for the period 2020 to 2021 was 40 initially, right?
Please, my lords.
But that came to be reduced.
My lords, that has been challenged, my lords. It has been subject matter. But later on, my lords, on the verification of documents for 22-23, my lords, they have increased from 40 to 60, my lords.
Sir, please understand, for the year 2021,
please, my lord,
your intake capacity was only 40.
Please, my lord.
Sanctioned by the authority.
Please.
So out of that sanction, as per Annexure A, that was reduced by 20% reduction in intake.
Because of, my lords, the deficiency what has been found.
All right. Now, whether that deficiency is rectified?
Please, my lords. Pursuant to that, my lords, 2 years, intake of 40 has been granted for next year.
Why are you confusing with the next academic year, sir? You stick on to that academic year of 2021, then come to your next academic year of 22 and 23.
Please, my lords. For the previous year of the challenge, my lords, that is 2019 also, there was an intake of 40. My lords, for some reason, my lords, for we not uploading the proper document online, this Annexure A came to be in place. Hence,
yes,
my lords, earlier also, my lords, there was a permission to run the college since 1997. For some technical reason, my lords, this Annexure A was supposed to be in place. Hence, the same has been challenged before this court. After seeing all the documents, my lords, this honorable court stayed the annexure A and permitted us to admit the students. In the subsequent event, my lords, we have produced all the documents which are necessary.
Where is that stay or interim order of stay? What does the interim order say? So pursuant to the interim order, you have continued to admit. What is the date? All right. So the interim order only suspended almost the annexure A, correct? Yes. Now, what was the compliance? It is only uploading of any documents or infrastructural and faculty also. All right. That pertains to which year? 20 to 21 or 21? Page.
Actually, page 36.
Page 41.
41 is for 2021.
No, 41 is for 1920 approval.
For 44.
That is 2021. Yes.
Here, third table. The last column reflects efficiency. This is of faculty member and decision here. All of them faculty being paid at the entire deficiency which is there has been noted in the last column. Wherever it is reflected as yes. It has been happening from 1880. This is a discussion we have made. So we have ever right? We can opportunity to this deficiency. Subsequently, my lord, in the year 1920 also we put it on the deficiency. But subsequently the he was standing hearing committee, the JCT, and we have documents. However, documents are not in order. Hence, my lord, the standing hearing committee recommendation of
20%.
20%. Subsequently, my lord, the matter was placed before standing hearing committee. Even there, the principal here, he did not satisfy the efficiency there as
before the appellate committee.
Therefore, the present order.
This is for 2021.
However, they subsequent year they have stated.
What is the order in your annexure A? Final, what is the order? No admission.
No.
In view of the deficiencies, SAC recommends to grant no admission to the institute for academic year 2020 and 2021. They have continued the admission by virtue of the interim order. All right.
Subsequent years, they have also intake to what? For the next year, it was 40 and subsequent year, it is.
All right. All right. That's all.
I'm
Yes.
sorry, my lords, I was locked out, my lords. Please.
What do you want?
My lords, now, my lords, at
Are you able to hear the argument of your friend?
my lords, I was locked out, my lords. I'm sorry, my lords.
That's your headache.
Sorry, my lords, sorry, my lords. My lords, my submission would be, my lords, for the previous year of this 2020, we had a sanction for 40 students, my lords.
All that is done, Mr. Counsel.
Please, my lord.
Simple facts of your case is,
Please.
earlier 18, 19, 19, 20, you had certain deficiencies which was pointed out.
Please, my lord.
Person, thereafter 2020, 2021 also there are certain deficiencies.
Please, my lord.
Due to which this Annexure A came to be issued.
Please, my lord.
Reducing the intake to 20% lesser than the actual quota.
Please, my lord.
Sanctioned.
Please, my lord.
You are not rectified that?
My lords, since we have rectified that, my lords, now they have given a permission. Before
For which
also,
year?
my lords, for 21, 22, my lords.
No, 2021 is not given to you. 21, 22 is given to you.
Please,
We're
my
not on that point.
Please, my lords.
Try to mix 2021 to 21, 22.
My
For
lords.
the year which you are now before the court is only 2020, 2021.
Please.
For that, have you complied with the deficiency? Simple.
Lords, we had the sufficient building plan, all these things, my lords. We would
Where
not.
is that? Please show.
I will produce the same, my lords. It has not been placed. Since, my lords, they said that if the permission has been given for the subsequent year, they will consider the same. That was the submission what the last time they have made. Since, my lords, I have not placed the same. Because, my lords, and 40 students, my lords, the intake was there for the previous year too. That is my point, my lords. Only to the technical reason that we could not provide them the documents. The extension, my lords, of the lease deed was not there in place. My lords, I'll put it this way, my lords, in a simpler manner. For the previous year, I had an intake of 40 students. Hence, my lords, the deficiency would not arise. Only problem was, my lords, the problem with the landowner. We could not get the extension, this thing. We could not provide the documents, my lords. The area-wise, we had the sufficient area to run the college. When the permission is there, my lords, for the previous year, only for the technical reason, my lords, this order has been passed. Hence,
see,
my
there are
lords,
certain rules and regulations put forth by the authority.
please, my lords.
You have to comply that every year only, then your intake is going to be approved.
Please, my lords.
You don't comply and you don't web host in the portal and you don't give your faculty members data, you don't file the reservation policy.
My lords, in my
Obviously,
ground,
it
I
has-
have clearly stated, my lords, earlier I have complied. This is not an institution which has been newly opened. The institution, my lords, is put in place from 1994. Since 1997, my lords, we are running an institution. It's not their case, my lords, you have taken a new permission.
No, if you are running it even during East India Company, that doesn't make any sense.
My lords.
If you don't comply with the deficiency requirement, please understand.
My lords, my problem
Your
was,
education institution thinks because you're running from the time of Babar ka Jamana, it will be continued. Sorry.
I'm sorry, my lords. I apologize for that, my lords.
Comply
My lords,
with what is asked to be complied. You get the
please, my lords.
compliance and you can continue with your
All
intake.
this issue has been arisen, my lords, due to the COVID situation. In the 2020, my lords, we could not communicate properly within our management because, my lords, the college was in Kolar and the staff also, my lords, we could not have a
No,
good
these are, you don't have to go physically, you have to web host it.
I will.
You have to web host it on your portal.
That's the technical glitch, my lords. The online portal was not working properly. We have mentioned in our
I'll
ground.
deal with it. You argue, I'll deal with it.
Please, my lords. I'll place the same record, my lords.
What you are going to place now? You are in the midst of your argument.
My lords. Since they made a mention, my lords, stating that if the approval is given for the next 2 years, we will not precipitate the matter.
No. He's admitting that approval is given for 2021 and 2022.
Please, my lords, and I have served the copy on them, stating that they'll verify the same
Sir,
and get
what's
back.
your name, Mr. Abhishek? You're Abhishek.
Please, my lords.
He is not disputing the fact that your recognition is given for the period 21-22 and 22-23. There's no dispute on that.
Please, my lords.
The only question is for 2021, have
Please.
you complied with these deficiencies at page 44, annexure F2? Pinpoint that and show your compliance and whether you have met them, complied with the compliances, and whether they have given you a go ahead green signal. Have you given? So what happens? All right, what happens if he has not complied? He cannot take admission. So that goes. So even if they have continued, they are not going to be approved. The students are going to lose. Correct?
My lords, the major deficiency which is being rectified, my lords, is at page number 46. Page number total area of land, my lords, available.
One minute.
Not say.
No. The interim order is that he can make admissions for undergraduate BHM course. How though? So his interim prayer is to permit him to make admission for undergraduate BHM course for a year 2020-21. Adu nimak kodabek or list, but the interim order is what he has sought for has been granted. He had sought for admission of the students for academic year 2021 for BHM course. Now, how does the procedure work after he makes admission? He has to give the number of list of candidates. Yes.
My lords, immediately, my lords, after 1 month of the said impugned order, page number 18-19, my lords, the complaints we have produced to the respondent number 2. Page number 20 is the details, my lords, what we have given. The explanation also starts from 18, my lords. The complaints. The second prayer, what we have sought for, my lords, to issue the mandamus to consider this and take a decision, my lords. The said lease agreement also, the deficiencies has been fulfilled.
What happened after this? What after annexure B? What happened?
In pursuance of an interim order, my lords, they have not taken any decisions, my lords.
Please read para number 3 in page 19. You admit that you do not have the PC's multimedia library and in the language lab.
Lords, that has been, the purchase order has been placed. Immediately after that, my lords, at page number 22, Annex B1.
No, that means you have not purchased. It was not there. You may have placed the purchase order.
My lords, the only major issue which was involved then, my lords, was to provide the lease deed and the property details, my lords. All the other deficiency are the curable defects.
It is not curable, sir. I don't understand. See, you are giving education to students.
Please.
If they don't have computer lab, if you don't have computers, how they are going to study? What knowledge are they going to gain?
My lords,
You are saying that you have placed the order for procuring. Will that come to the students who have already passed 2020?
my lords, the academic year will start at the present, my lords. Before this permission has been given, we have to take all this thing, my lords. If the deficiency has been notified, immediately it has to be cured. Immediately it will be, permission will be granted. The only defect which we could not resolve was, my lords, the lease agreement.
No. Please see number 2 at page 16. Computational facilities, number of PCs in language lab, compliance not accepted. No relevant document presented and deficiencies still exist. Next, library facilities. These two are important. Even if we condone your land details and the piece of minimum per piece area.
Even considering that, my lords, before the commencement of the academic year, we have done so and given the representation to them.
Where is it? Where is
it? That is at page number 21, my lords, Annex B. The enclosures we have done at page number 22. The lease agreement, the enclosure number 1, lease agreement, 2 and 3 gift deeds, 4 is blueprint of the college, 5th is a purchase order.
Yeah. Are you able to understand? The purchase order itself is a proof of record that you have placed purchase now on the date of issuance of this annexure, that is on 2020. So that means that as on 2020, 6th August, when already half the year is over, you did not have these facilities. Is that your argument, Mr. Counsel? That is your argument?
However, they have a disclosure. It has to be however, connection has to be a mechanism. For 2021, mandatory disclosure of 2008, 9 and 10,
This is common for all education institutions.
Supplementary member, which are to see. They have the format. So particular email ID and that.
Which page?
34, which are out to see.
34.
But in the land details, it has to be sent to the address, land detail at AICD.
Sir, land details are all curable, please understand. We're talking about education institution. If land is there, education institution is there on the land, whether it gives today or tomorrow, that is only a curable defect. The question is whether they had the faculty teaching the infrastructure for PCs and lab.
All that may not, they have to send the requisition, not through physical copy. It has to be sent to a particular email ID. The principal of the institution has been notified to the by our email to the 20 in 24 to 20. However, instead of sending the information to the relevant email ID, it does not deal with this. And the entire process has been defined in our upload process act. What they have.
So whether they have now complied with the deficiency of no, you're not concerned about subsidy. I don't know why you people keep on arguing and harping on subsidy. We're on 2021.
This may not have included. It can be a question of
so that means to say if you have given for subsequent year approval, the previous year automatically retrospectively gets approved?
No.
What argument you are making? You're an institution. You are representing whom?
Yes.
ACT. You are the person who has to give the approval. If you have given approval for 22-23, then automatically 19 and 20 or 2021 gets approved. Then your annexure A should go. If that is your argument.
My argument is, my lords, on 2020 itself, we have complied the same before coming to this honorable court.
Show it, sir.
My
Show
lords,
it.
page number 18, 19, my lords, is a reply given to annexure A. The
Page number 18, 19.
Please, my lords.
In that page number 18 itself, you say you admit your mistake. Page 19, para 2. Please read.
The blueprint of Sambram Hotel clearly project classroom, tuition room, seminar halls, labs with also language labs, and this is proof duly signed by the appropriate authority. We admit our mistakes to unclear the documents were wrongly placed before the SAC at the time of scrutiny. The entire college building was used for the academic purpose only. Regarding the deficiency of PC in library multimedia in the language lab, we have placed the order for additional PCs. Now we have submitted that the academic year shall be upgrading the above said library and language lab. My lords. Page number 21.
So para number 3 regarding deficiency in PC. You have placed the order for additional PCs.
Please, my lords.
It's your own admission.
Page number 21, my lords. For curing the same and submitting, my lords, with the enclosures at page number 22. My lords, this is for upgrading of a library, my lords. There is no, it's not a contention that there was no library at all. To create a multimedia library, my lords, an additional purchase order was placed.
No, the question was that you don't have, there is deficiency of PCs in the library and multimedia. You have said again in para 3 in page 21 that we have placed an order for additional PCs as per AICTE requirement.
Please, my lords. My lords, it's not their case that we did not have a facility at all for the earlier academics.
Please show how you have complied this number 3 deficiency of library facilities, multimedia PCs not accepted. Relevant documents presented deficiency still exist.
My lords, I'll place the record, my lords. Right now, I have not produced the same. Since I have given the...
All right, what is your argument?
Yes, it's based on the they are done, they are what? And by your order. But they were having.
So what happens? What happens to the interim order which is granted? If the interim order was not granted, they would not have admitted. All the problems in the education institutions begins with the interim order. Despite the Honorable Apex Court saying in several judgments, the High Court should be very careful in granting interim orders. If then itself no interim order was granted, they would not have taken and put these students into this precarious situation. Now, who's the person who's suffering? The students. What is the point in imposing penalty on them? What happens to students' career? You should oppose to such orders. That's party. No, then he should file. They again face the same problem of non-recognition. So what's the point, law on the point? The Apex Court very clearly says you should not, first of all. Huh? So now after this annexure A, whether they have come and approached you for having complied by letters.
Cannot be considered. Keep for weightage.
Correct. So the appellate authority again, your appeals authority, what do you have that? Standing appellate authority will have to re-inspect after the say that they have complied and sanctify if their compliance is in order. Whether you have done that, whether they have given and have you done it? That is what has to be done. Because he says he's relying on the annexure B and 1 and B and B1, which is post annexure A, by saying that here they have produced, made some procurement of labs and computers and advanced PCs. If that is considered by you and you have again gone and inspected and given a clearance, then they will have the benefit of this order. That is what you have to verify. Otherwise, what is your role, Mr. Singh?
Yes, right, there is a definition by AIC in the body. The user cannot be affiliation.
So you are for the university. You are a formal party. Yes, Mr. Abhishek. So you place this material.
Please, my lords.
Please do it. When do you want to do it?
My lords, 1 week time, my lords.
All right. Perfect.
My lords, in the meantime, my lords, if the respondent number 2 verifies the said documents, my lords, that would be appropriate is what my prayer. In pursuance of annexure B, if they verify it, my lords,
But I have to argue the matter for some time. Learned counsel for the learned counsel representing the petitioner submits that in response to annexure A, annexure B has been got issued by the college management to show that they have complied with the requirement of deficiencies pointed out by the AICTE. Which respondent are you? Respondent number 2, Allah? 2 and 3. And thereafter also got issued annexure B1, wherein certain enclosures are made regarding compliance of the deficiencies pointed out by respondents 2 and 3. 3 and 4, 2 and 3.
2 and 3.
Learned the counsel representing the respondent 2 and 3 to verify the same whether any further inspection has been done pursuant to the complaints alleged to have been met by the college bar petitioner and to place a submission by way of records on the next date of hearing. So also learned counsel for the petitioner is at liberty to place material before the court to show that he has complied with the deficiencies pointed out by the respondents 2 and 3. Relist this matter on 2 weeks.
Please, any date, my lords, at your lordship convenience.
Next date 41. 2 weeks on date 18th January.
Obliged. Obliged.
So this is 96. Huh? So 7, 98, 99, 100 are all adjourned. Hardly a 452 3 mark. Yeah, where are you, madam? All right, you submit in the afternoon. You want to withdraw, no? Okay, you show it at 2:30. Ajay Kumar Patil is here. Mr. Kamath, your senior counsel here. You're ready, Allah? You're ready.
Hello, court officer. Court officer.
ಹೇಳಿ ಮೇಡಮ್.
ಮ್ಯಾಮ್ ನಂಗೆ ಸೀರಿಯಲ್ ನಂಬರ್ 74, 75, 78 ಡೀಟೇಲ್ಸ್ ಬೇಕಾಯ್ತು. 74, 75, 78 ಮ್ಯಾಮ್.
ಏನಾಯ್ತು ಅಂತನಾ?
ಹಾ ಎಸ್ ಮ್ಯಾಮ್.
74, 75, 61, 76 also 61.
ಓಕೆ ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್.
28. 28 after 2 weeks. ಇದು ಯಾರಿಗೆ? ಇದೇನು ಎಕ್ಸಾಮ್ ಬಂದಿರೋದಾ? Lavender. ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ನೀನ್ ಬರೀತಿಯಲ್ಲ ಯಾವ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಬರೀತಿಯಲ್ಲ ಅವಾಗ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಸರಿ ಎಂತ ಬರೀತಿಯಲ್ಲ ಈಗ ಸದ್ದಿದ್ರಲ್ಲ
One or two last.
ಆಮೇಲೆ ಆದರ್ಶ ಇವರೇ ನೋಡಿದಾಗ ಅವಾಗ ಸ್ವಲ್ಪ ಒಂದೊಂದು ಮ್ಯಾಟ್ರ್ ಏನಾಗುತ್ತೆ ಚಿಕ್ಕಟ
Education ಬಂದದಲ್ಲ 101. Mm. 102. You are in 102. Appearing for? What objections? This is 2022 matter. ಇದರಲ್ಲ ಇವರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ರ ನಮ್ಮ ಕಾಮತ್ ಪಾಸ್ವರ್ಡ್ ಕರಿ
Matters. Okay.
Right? Liability RML fix agide. Right. Who are you? Claimant. So what do you want to do? Para number? Huh? 15. Ah. Odi. In ground ತಗೊಂಡಿಲ್ಲ R1 being the owner, he is being asked liabilities fixed on him to pay. You are a claimant, so you want to shift the liability. What do you want? ಏನ್ ಬೇಕ್ರಿ ನಿಮ್ಗೆ? ಏನಕ್ಕೆ? What do you want to do? At least you tell what the court. I don't know. Come and stand in High Court. Since how many years you are practicing? 7 years. ಏನ್ ಬೇಕು ಹೇಳ್ರಿ ಕನ್ನಡದಲ್ಲಿ ಹೇಳಿ. Now you are sought for enhancement of compensation. Now what else? I will hear you on pass orders. ಏನಕ್ಕೆ next week? No, if you are not ready, I will read the paper and I will pass orders. For what? To argue or you want to file application? Have you raised the ground of shifting the liability? Is there an insurance policy?
May I submit? I appear for the respondent. There was no insurance policy. The policy number refers to some other vehicle.
You're appearing for R2.
House owner.
Insurance policy illa idralli.
Insurance policy illa. Unfortunately, they have also not raised the ground. They also know about it. I had spoken to Mr. Kalyan long back.
R1 ಯಾರು?
Abdul Razak.
ಆಯ್ತು ಇರ್ಲಿ. Ex parte ಆದ್ರೆ ಆಯ್ತು. There is no insurance policy now. So you have an ex parte order against the owner against whom the liability is fastened. He has to pay. You cannot recover from him. Whether FIR is there? Document illa 2013 ಅಲ್ಲಿ. This is ridiculous. None of you are ready to argue. 112 matters I have called out from 10:30. What were you doing all these years? When do you file wakalat? Nothing. 10 years you have slept over the matter. What relief you are going to give to your client? At counsel for the appellant, claimant seeks time. Counsel for the respondent number 2 is present through video conferencing. Release this matter on 6th. Arne Tarik, whether you argue or not, this court to pass orders. Appeal against R1 dismissed. Claimant's appeal, you know. What? Jay Prakash. That is the United Insurance Company. They will not come. The petition is dismissed. Despite calling out the matter for the second time at 2:41 p.m., there is no representation on behalf of the appellant or the respondents. Hence, release this matter on 9th January to provide an opportunity to the appellant to address arguments. Yes. 70. You are appearing for United India Insurance. Insurance ಮೇಲೆ dismiss ಆಗಿದೆಯಲ್ಲ. Why you want time? Why day after? Why not today? Enhanced by which court? This court, High Court. The second round of litigation. Your claimant, Allah, you are seeking enhancement. Are you seeking? ಎಲ್ಲಿದೆ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ನಿಮಗೆ ಮಾಡಿರೋದು? Where is the enhancement? Huh? RP. The insurance company had gone in review petition. What is the judgment of 14/10/2014, madam? There is an order of 14/10/2014. You are having the file with you. Really? What is the order of the MFA court initially? Initially, what was the order made? MFA by this court. ಏನ್ ಮಾಡ್ದು ಈ ಕೋರ್ಟ್ ಏನ್ ಮಾಡ್ದು ಈ ಕೋರ್ಟ್ ಏನ್ ಆರ್ಡರ್ ಮಾಡ್ದು You're appearing on behalf of Yaru A.N. Krishnaswamy. Don't insult your senior. You are coming and walking into your, this is a panchayat office without even the file. You don't have anything apart from the judgment copy. ಯಾವ ಜಜ್ಮೆಂಟ್ ಇದೆ MVC ಜಜ್ಮೆಂಟ್ MFA ಜಜ್ಮೆಂಟ್ ಏನಾಗಿದೆ ಗೊತ್ತಿಲ್ಲ ಯು ಡೋಂಟ್ ಹ್ಯಾವ್ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಜಜ್ಮೆಂಟ್ ಇದೆಯಾ ರಿವ್ಯೂ ಆಲ್ರೆಡಿ ಯು ಆರ್ಗ್ಯೂ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ You are also half read than him. Court ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ. You want to come and argue final hearing. ನಿಮ್ ಪೆಟಿಷನ್ ನಿಮ್ ಸೀನಿಯರ್ ಯಾರ್ರಿ? ಮಹಾನುಭಾವನ್ರಿ ಒಬ್ಬರ ಮೇಲೆ ಒಬ್ಬ. Who's your senior? B. Siddaramaiah. To be given gold medals. Review petition allow agi fresh consideration ಮಾಡಕ್ಕೆ ಹೇಳಿದಾರ? ಮತ್ತೆ you are happy with 86,000? It's a case of death or injury. What is this, sir? You should be ashamed of yourself. Ridiculous. Review petition order idea. Huh? Read it. Read from paragraph number 5. ಮುಂದೆ ಹೋದ್ರಿ ನೀವು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಗಲ್ವಾ? What is the violation of the terms and conditions of the policy? ಯಾವ ಪ್ಯಾಸೆಂಜರು? Because of that gratuitous passenger. So liability is now confined only to the owner, according to you. But what is the order in the review? It is appropriate to set aside the impugned judgment, restore the appeal to its original file for hearing afresh regarding liability. So a fresh hearing on liability has to be heard and passed. First order itself was not correct. Second order more also is again. You have gone before the court to set aside the order which is passed against you, because in the tribunal has exonerated you, insurance company, and fastened on the owner. ನೀವು ರಿವ್ಯೂ ಹಾಕಿದ್ರಿ. ರಿವ್ಯೂ ಹಾಕಿದ್ಮೇಲೆ ತಿರ್ಗಾ ಫ್ರೆಶ್ ಕನ್ಸಿಡರ್ afresh ಅಂದ್ರೆ again liability will have to be considered afresh. whether you are liable or not. So you have to argue whether why you are not liable. Why? Gratuitous passenger, which is the judgment of the Supreme Court. What is that? Manora Khatun? Have you heard of that judgment? Even gratuitous passenger, you are pay and recover. Fundamental breach, full court judgment of the Karnataka High Court. What is that? Which is that full court judgment, Madam Shivappa? Na? How did? Yellava. Yellava's judgment. In that ವರ್ಷ ನೀವು ಏನ್ ಕೃಷ್ಣಸ್ವಾಮಿ ಆಫೀಸರ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ ಅಂದ್ರೆ you should argue, not come just swinging your hands to the High Court. Don't create this institution to a mockery. ಅವ್ರಿಗೂ ಏನು ಗೊತ್ತಿಲ್ಲ. You don't want any enhancement. Don't want. I will record it. ಏನ್ ನೋ ಅಂದ್ರೆ ಬೇಕಾ ಇಲ್ಲೋ ಬೇಕು. ಅದಕ್ಕೆ ಎಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಿರ ನೀವು? You are saying 86,000 to be given. That's all. What is this pathetic situation, Mr. Prasad, of this Bangalore bar? I don't know. I'm coming from Kalburgi. Their advocates are doing far better. I'm saddened by this arguments. And we say that the bar at Kalburgi and Dharwad is lower in this one than compared to Shivava. Nim senior goskara, this High Court is not going to stand still. Let him be any senior from Delhi, doesn't matter. This court is not going to wait for your senior. Wherever your senior is, he has to log in and argue. Please tell this to your senior. I'll post this matter on 5th. Just one thing which I partly heard, further hearing and not. Heard in part, Leonard Council. Tell your senior, whoever is going to argue, don't commit this gross injustice to your client. Your client is coming thinking that you are going to do justice to your client. If he knows, if he hears your argument, he'll file a case of negligence against you both. Please understand. Advocates have taken it very lightly. Don't do such a gross error and cause injustice to your other bar members who are brothers who are burning midnight oil. Understand? They are not raw genius. How many years you have spent? 6 months. So he can be pardoned. You have 110 years. 6 months, then you should take time. You don't know to argue, then you should tell your senior to come and argue. We list this matter on 5th. Filed by, appeal filed by? You're ready? Ready to argue? Where is this Pramod? Who's this R Pramod? Order sheet not even. He's asked for a enhancement. In global compensation ಕೊಟ್ಟಿದ್ದಾರೆ. Huh? ಇದೆಯಾ? Hello? Who's R1? R1 yarappa? Owner of the vehicle? Which vehicle? Who's R2? Have you read it? R2 is Madhu Alvendri. Huh? Rider of what? Please read the cost. Read it. You have the judgment copy with you. Please read. Tara? Read it. Where is that contributory negligence ಮಾಡಿದಾರ? Huh? How? FIR is there. FIR and charge sheet is filed against whom? Charge sheet to FIR ಯಾರ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ? R2. Is the rider of? Then where is the question of implicating the petitioner who's riding bicycle? So R1 is the owner of the bike and R2 is the rider. No insurance, no insurance. So R2, R1 has to pay. Huh? Madam, see order dated 20th July 2016. Why notice is dispensed? He's the one who has to pay. New year, huh? R2. July 2016. Payment is ordered to be paid by R1. Notice ಅವ್ರಿಗೆ dispense ಮಾಡಿದ್ರು ಯಾರು payment ಯಾರು ಮಾಡೋದು? Even otherwise, the rider is not the one who has to pay. It is the RC holder who has to pay, owner. Where is the question of a rider coming and paying the amount? Why did you agree for dispensation? All right, you are respondent number 2. Why you kept quiet? There's no representation on behalf of appellant claimant. Learned counsel for respondent number 2 is present. Right, the judgment, impugned judgment, the liability is fixed on both respondent number 1 and 2 jointly and severally. Pay the compensation amount. Respondent number 1 is none other than the owner of the offending vehicle involved in the accident, that is motorcycle. Whereas respondent number 2 is the rider of the motorcycle, against whom the FIR and charge sheet came to be filed, correct? But while order dated 20th July 2016, at the instance of appellant, notice to respondent number 1 was sought to be dispensed and accordingly it came to be dispensed. Hence, there is no representation on behalf of R1. Learned counsel for the appellant to put forth his submission with regard to dispensation of notice to R1. Released on 9th January. Note ಮಾಡಿದ್ದೀರಾ? Say what is passed. Mr. Prasad. Execution is not fully satisfied. It's filed by the DHR. So in the execution petition, you are the decree holder. That is Kappanna and Sons Engineering. Who are the judgment debtors? That is Railways, I think. There is a council. He appears for Railways. Only the other. In the execution, what happened? Execution ಅಲ್ಲಿ ಏನಾಯ್ತು? I have that. Again, the decree holder is liable to pay balance fees.
The arbitration will be arbitration is held between the parties. In terms of the award, the arbitrator has held that if you delay the contract, and the contractor was held liable to pay 10 lakhs, that was not paid. All came to the pass on 28 September 2016. Agreed by this award. I have by the
Contract.
Finally, go to the award. The awards, the execution, the sum of rupees 16 lakh 85 crores the first, 3.2 of the other.
By JDR.
Then I not paid interest. Only the first. Yes, sir. But do not challenge you are not like. Okay. Yes, filing of the JDR from the first. Because the delay in the first, they are
10%.
and board also had, since I did not pay 10 lakhs time, that amount had to be done.
Correct. 76,904. So you are also liable to pay 10%.
Transport has taken a very good pain, very good.
So now this execution is that 20 lakhs has to be paid by JDR. That is, so that is in challenge. Have you paid that 10% and larger amount they have to pay? So they can deduct that 76,904. What is 10% of that? 7,000 something. 7,690. That is challenged here. Whether this was argued earlier, bench? No. What is their argument? What is their ground and what is their argument?
They say that I can challenge the amount by paying. We are not entitled to pay the interest.
Whether you have challenged, they have challenged. If you had deposited the amount then and there, of course, yes.
Nothing like that. No interest is a liability that passes on. That is this.
Barkol. Heard. Learned Council Sri ST and Prasad for respondent number 1. There is no representation on behalf of petitioner. In order to provide an opportunity to the petitioner to have a say, release this matter on 10th or 11th. When is released on 11th to facilitate the counsel for petitioner to have a say. The further hearing. What has gone wrong with the bar?
CTC matters, moving the matters, the 10:30, they should dispose of that, saying that the matters are not taken. No, the matters are being listed at tomorrow.
It finished 100 matters at 1 o'clock. Nobody is willing to argue. Nobody wants an order. They want only adjournment. Now, ಏನಾರ ಹೇಳಿದ್ರೆ judge ಹಿಂಗ್ ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ members of the bar. Sir, GMCPC, education matter, SC/ST, MFA, MVC. Nobody is willing to argue. And you want to blame the judiciary for pendency, who has to be blamed? No, what will if now your live stream, what will happen? What public will think? What your litigants, your clients will think? Whether are you doing justice to your clients? Yes, sorry, state of affairs. Yes, madam. Yes, what is that you want to file? What is covered? Please use the mic. Please use the mic. You are appearing for the petitioner plaintiff. Yes. Yes. What is put in challenge?
As the suit is now taken from this item petitioner board is not property of the first board is not. The same is so please, this will.
By disposed of what? By saying what? Where is that order? Return of plaint agite, no? Return.
Is only for respond number 1 and 2. The driver is also a part.
Application came to be filed under which provision? For what? Rejection of plaint.
Return of claim.
Madam, 7 rule 11, return of plaint is different from rejection of plaint. Please understand. What is the application?
PF ಕೊಡ್ಬೇಕಲ್ಲ ಅದನ್ನ?
ಕೊಡ್ತೀನಿ 1 week time.
ನಾವು ನಿಮ್ಗೆ ಕೇಳ್ತಿದ್ದು
You are plaintiff or defendant? Trial court. So you filed a suit. Who filed the application? For what? What happened to that? Same is allowed. So you challenged it. What happened in that? Hmm. Hmm. So that review is dismissed. Agreed by that review, you are before this court. So similar things was also passed in this judgment is what you are trying to say. So where is the question of application having been filed under Order 7 Rule 11D? Who was filed? You said you filed application under Order 7 Rule 10. You be clear which application is filed under which provision. For what? Rejection of? Whether application was filed under Order 7 Rule 11D or application under Order 7 Rule 10 for return of plaint. Be sure, open your records and see. Even in the High Court coordinate bench order also it says Order 7 Rule 11. In the order passed by the civil court, which you are now impugned, it says Order 7 Rule 10. Which is to be believed? Now, if I pass an order based on the coordinate bench of this court, I am again going to commit a mistake based on your submissions. No. I don't know how you people are going to rectify yourself. There is an application on record which is filed under Order 7 Rule 10. You know the difference between 7 Rule 11 and 7 Rule 10? 7 Rule 10. CPC Kandila. When you come to CPC court, please carry your CPC. That is the Bible. The coordinate bench has found Order 7 Rule 11. There is no such application. Coordinate bench would have relied upon your statement. Objections is filed under Order 7 Rule 10 application. Total confusion. You are relying on the judgment of His Lordship Justice Arvind Kumar's of 2013. Online Madhigara. So that was CRP. How CRP would be maintainable under Order 7 Rule 10? Total confusion in your entire petition amendments, I think, which is also caused confusion in the coordinate bench judgment and also the earlier judgment. Application came to be filed by the defendant for return of plaint under Order 7, Rule 10. Correct? Was it filed under 7, Rule 11? It was not filed under 7, Rule 11. Because if you file an application under 7, Rule 11 and if it is dismissed, you cannot file CRP. You have to come under WP. You have gone in civil revision petition. There also it is shown it is the impugned orders, Order 7, Rule 10. Operative portion says rejection of plaint. Rejection of plaint is Order 7, Rule 11. The other judgment which you have relied also says the same. You make wrong submissions and get some wrong orders from the court. And if I pass one more order, there will be a bunch of wrong orders. We perpetuate the wrong. What is this matter? Please be clear about your own case at least. Application is here. Application is filed under Order 10 Rule, Order 7 Rule 10. That is for return of plaint. For bar of jurisdiction. Return or rejection or Atila. Please read your papers and come. Judgment code, let it be here. You have a copy of this with you? You have? No, you can take one more printout. Let this be here. Learned counsel for the petitioner seeks time to ascertain the facts with regard to whether application is filed under Order 7 Rule 10 or application under Order 7 Rule 11 to make correct submissions before the court. Same is granted, release next week. You wanted this court to do what? You made some submission of withdrawal or to pass an order on the basis of this. You are ready next week.
Ajay Kumar Patel.
The Shivkumar CGC. None appears. Either of the parties. Once release this matter a week after next. Does this petition?
Yes. That's it. Respondent.
Court officer. Appearing for Union of India, my lord. 102 serial number.
The Bangalore University, chemistry and mathematics are one of the subjects. Yes. Chemistry and biology. No, they will give equal certificate. Not chemistry and biology. Now, the students' simple plea is that in the university, you will write mathematics. So everyone gives so,
What objections you want?
Upon 8th of the course admission for 2 years we will not get the admission. We will not get the admission. I have to either give up this in life. I will give up my possibility of it will be very costly.
So all these students are undergoing B.Ed course.
Yes.
Which year?
So you have to do a mistake.
It's okay.
Yes, previous.
He will put it in that manner only. We'll have it tomorrow, day after. Whenever you want. Tomorrow, because if there is a last date of 8th. Yes. Mm. Mm.
Also. The direction.
Permit.
So, yeah, permission. Yeah. That is related.
Just read the prayer. Read the prayer.
There is randomness direct. One of responded, of the studies and biology indeed they are prepared to write the examination. Some in the
Alternatively.
Alternatively, in the event of any, if for any reason example old, such an event, the second the petitioner could be based on the studies in BA course and responding around Kaluri. We are not concerned. There. Third, the question is bringing the issue of equivalent certificate by other universities situated outside Karnataka. The petitioner, any student cannot from anywhere. We are 9 universities. And college offers BA courses. It's getting combinations. If I come from Delhi or whatever, Bihar or Andhra, I have to join only the course which I have. I cannot say my home state insists on mathematics. Mathematics is not there in my college. Because already not joined to the course, they study that subject, and now say, home state is not equally giving the equivalent certificate.
So he is asking you to conduct mathematics examination. So you don't have mathematics. So you want. Yes.
Mangalore University. 1, 2, 3, 4, 5, 6, 7, 8, 9 columns.
So.
Here, chemistry and mathematics. Mangalore University has course for mathematics. Just requesting, in my college, there is a chemistry and biology. Because the Kannur University is not recognized the mathematics, biology.
No, but have you taken the course for mathematics?
I am ready to write mathematics.
Is this, sir?
No, I am ready to.
You may be ready. You may be ready. You go and join PCMB. You want electronics evidence, electronics subjects examination to be conducted, which is not even your course.
If there is a two subjects,
The university can conduct exam for any of the courses.
Provided you join that course first.
The university is not.
So according to your argument, our Bangalore or university should go according to your requirement of Kerala, Andhra, Tamil Nadu or Punjab. That is what is your argument. All right, you file your objections, Mr. Yes. Huh? That I'll permit you. That's it. See, what are minor things that you can do? That's it. Actually, we'll consider it. If you are entitled to convince me, I have not decided, I have not framed up my mind. Learned Council, Learned Senior Council, Mr. Kamath, representing on behalf of Learned Council Purushottam V for petitioner, submits there are certain minor errors crept in the petition which he seeks to correct. Same is permitted. And Learned Council Sunge, appearing for R1, does not have any objection for such corrections. After corrections, a copy of the corrected petition may be served to Learned Council for the respondent. Full stop. Learned Council for respondent R1 is permitted to file objections, if any, to the writ petition within a period of a week. Time already. Monday we'll have it on 9th. We list on 9th. Who appeared? Somebody appeared for central government. I think wrong submission. That must be previous case. Kannur, who's appearing? Nobody is represented. ಇವಾಗ ನಾಳೆ ದಿನ ನೀವು ಅಲ್ಲಿ ನಮಗೆ ಮಲಯಾಳಂ ಬೇಕು ಅಂತ ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಮಲಯಾಳಂ ನನಗೆ ಎಕ್ಸಾಮ್ ತಗೋಬೇಕಂದ್ರೆ ಮಲಯಾಳಂ ಕೋರ್ಸ್ ತಗೊಂಡಿದ್ರೆ see, for example, CMP or bachelor's degree, let us say history, economics, political science, or biotechnology or chemistry, you will have to take one option subject of Hindi or Kannada. Suppose your state is Bihar and they say that you have to take Hindi, whereas you have taken Kannada, and that is not even your course.
When I was in number of students had taken Kannada. The Sanskrit was a scoring mark. And people who had taken science, BC, MBA in yes, they wanted to score more marks. So there was a discussion. First year they have predicted. Second year their this thing certificate has to go to the board. The board has to give the hall ticket. 4 months before that process is started, all the students requested the principal that they take the notes and it was very sad. When they take,
have you changed? Okay. Right here, have you taken? First of all, here have you taken permission to do mathematics? Mr. Senior Counsel, if you want to do mathematics course, apply to them. If they are permitting you, take up the course, then you do and go and show it to Kannur University or whichever.
Page number 20, election A. ತಾವು ಮಾನವೀಯ ನೆಲೆಯಲ್ಲಿ ಸೆಮಿಸ್ಟರ್ಗೆ ರಸಾಯನಶಾಸ್ತ್ರದಲ್ಲಿ ನಡೆದ ಒಂದು ಸಹಾಯ ಆಗಬಹುದು. ಈ 3ನೇ ಸೆಮಿಸ್ಟರ್ನಲ್ಲಿ ಮೊದಲ 4
Human rights. Ado our permission kotre, fine. If they don't, then first you have to challenge that and then come back to this. Now you can't stay. We'll have to check the university rules on that.
The Karnataka actually we don't know anything. We will not try to get the order from the court.
That's what I said. See, if you have taken physics, chemistry, biology, that is your course. Suppose you want a job requirement of mathematics, then you have to take physics, chemistry, biology, mathematics. Or you leave out one subject and take mathematics. First ನೀವು ಸ್ಟಡಿ ಮಾಡಿದ್ರೆ ತಾನೆ ಈಕ್ವಲೆನ್ಸಿ ಕೊಡಕ್ಕೆ ಅವರು. You should have realized while you filled up the form while taking the course that you are going to have a job requirement of this and that job requirement requires mathematics. ಕೇರಳ ಅವ್ರು ಏನಾರ ಮಾಡಬಹುದು, ನಮ್ದು ಕರ್ನಾಟಕ, ನಾವು ಇದು ಕರ್ನಾಟಕ ಫಾಲೋ ಮಾಡ್ತೀವಿ. Even if it is closest for requirement of job, for appointment also, there are certain classifications required, and biology, microbiology, sociology and psychology. The particular subjects have to be taught, only then it will be equivalent. Otherwise it is not. Or the notification will have to specifically declare that this is equivalent to so and so. Otherwise you are not entitled as a matter of right. You can't invoke article.
They are not represented. Yeah, university government authority. That's the alternative.
I think fine. Aitama. Stay in that. How the merit value. Mr. Senior Counsel, Kamath, why none of the advocates are willing to argue the matter? So 4 o'clock, I am forced to get up. At 1:30, I finish 112 matters.
All the please. There are not. Not taken as well. First the others.
ಇಲ್ಲ ನಾವು ಮಾಡಬಹುದು. See, if I do that, what is there in your mind to address argument if a particular point is there, which is missed out by the court, will affect the justice to the client. No difficulty for this court to pass orders. No, I am now going to do that in future. Heard further arguments, opportunity will be given. If you come and address, very well and good. No, I am liberal in giving more compensation. The other day, one lady said she wants 3 lakhs. I got awarded some 8-9 lakhs, 7 lakhs. Still, they don't want to argue. No hangover. Hangover. No, but I am saddened by the functioning of Bangalore bar, thinking Dharwad and Gulbarga is inferior. No, they are all doing extremely well and getting ready and arguing the matter. I hope.